Ms. Wilcox, please.
My lord, my lady, de facto directorship. As you will well know, the test for whether a person is a de facto director is not statutory, but judge-made. At the risk of labouring the point, the concepts of shadow director and de facto director are distinct. This is not an either-or question. If one is alleging someone is a shadow director, one needs to prove that the statutory definition is satisfied. If one is alleging de facto directorship, one needs to satisfy the judge-made test. It is possible for someone who is not a de jure director to be involved in the affairs of a company without being either a shadow director or a de facto director. What is impermissible and what the claimant sought to do below unsuccessfully is just mass everything together and say equity must be one or the other. Just one of you. The trial judge dealt with the de facto directorship question from paragraph 312 of his judgment, to which we'll return in a moment. But first, I just wanted to remind the court of Lady Justice Arden's remarks in Smith and regard to which I alluded before the short adjournment. So in Authorities Bundle 3, tab 11, I might ask my lord, my lady to turn to page 563. You'll see under the heading practical points what makes a person a de facto director. Lady Justice Arden sets out a number of propositions to which the judge referred in his judgment, as we'll see in a moment. The point I wanted to highlight in particular is on page 564. It's not controversial that these are the principles. The judge applied them. The judge was right to cite them. There's no error of law suggested. Paragraph 45, Lady Justice Arden says, in my judgment, the question of whether a director is a de facto or shadow director is a question of fact and degree. The principles of appellate review are well established. I think they summarise those applicable here. Where the decision depends on the judge's assessment of weight to be attached to various facts, the test to be satisfied on appeal is that in most cases the judge was plainly wrong. Where the appellant contends that the judge misdirects himself as to the law of the judgment, the court must determine what the law is and whether the judge applied it. Well, there is no misdirection of law here on the grounds. So we're just in factual challenge. I showed you before the short adjournment the factual challenge to the shadow director question is hopeless. The factual challenge to the de facto director question is equally hopeless for reasons I'll seek to show you. If you could put away the authority for the time being, please, and then turn to paragraph 312 of the judge's judgment, which is at page 156 of the core bundle behind tab 7. And you see there the judge referring to Smithton, as I said, he did. And then identifying that the question is to be determined objectively. Immediately before that, saying the key points are whether the person is part of the corporate governance system of the company and whether they assume the status and function of a director so as to make themselves responsible as if they were a director. And then the last sentence I'd also just emphasise in this context, it is relevant whether the company considered them to be a director and held them out as such, and whether third parties considered that person was a director. There's no suggestion in this case of equity being held out as a director or of anyone considering equity to be a director. 313 is just a reference to an earlier decision of Lady Justice Arden. That's really a remark in passing in an earlier case. The de facto director was shown to be one of the nerve centres from which the activities of the company radiated. We then come on to 314, and this is, in my submission, another example par excellence of the judge doing exactly what he was meant to do. He took on board Mr. Parker's legal submission for what it was worth. He recognised that in one sense, equity was the nerve centre, but then explained that sense, and then gave his reasons for saying that it was not a de facto director. It was, the judge found, setting the strategy for the whole group. That's not de facto director business. That's trust administrator business. And as the judge said, Mr. Brown led the team in equity trust with responsibility for the structure, and so discussed matters of strategy and proposed transactions with Buckingham and Mr. Hallaby. So, Mr. Brown, wearing his equity hat, thought about strategy and trust administration, and absolutely some day-to-day management of the claimant companies. It is, however, apparent from the documents, so again, a finding based on the contemporaneous documents which this court could not possibly go behind based on Mr. Parker's cherry-picking. Strategic proposals related to key issues such as purchases, refinancing, the proposed initial public offering, possible sales, all or part of the portfolio, came not from Mr. Brown or anybody at equity, but from Buckingham and or Mr. Hallaby. It's another finding of fact. It's unimpeachable. You may remember, we'll go back to ground 23 by way of cross-check at the end, as I promised we would, but you may remember that the first subparagraph of ground 23 is that the judge wrongly took this into account. I do not understand that contention. It's not wrong for the judge to make a finding that strategic proposals emanated from people other than equity in rejecting the submission that equity was a de facto director. That is obviously logically sound. He made a finding, it's an unimpeachable finding, and then he drew a conclusion based on that factual finding. There is no suggestion that the claim from the claimants that Buckingham, Mr. Sear, and Mr. Hallaby should be treated as de facto directors. Well, quite. And it's right that proposals were put forward in the way that I canvassed in relation to shadow director question. But as the judge says at 316, there was a discussion with Mr. Brown wearing his equity hat, his equity team, Buckingham, and then refinement with professional advice. Here, it's the second sentence of 316 that I was referring to earlier when I said the judge explicitly takes into account the fact that advice was given to equity. It was addressed to equity. That's fine. It doesn't make equity a de facto director for one moment. Equity did the legwork, put a proposal to the board. The board did what boards do and decided whether to approve the transaction as formulated by equity and Buckingham and the professional advisors. In 317 and 318, I just invite my lord, my lady to read or reread those. The key point in 317 is, of course, the first sentence. There's just a disconnect between saying someone came up with proposals to put to the board and saying, therefore, they were a de facto director. Does not follow. The judge makes exactly that point at 318. The very fact of key decisions being referred to the board shows that equity played a non-directorial role in the governance structure. it did not assume responsibility to act as a director. He adds in parenthesis, whether knowingly or not. The fact that the day-to-day management of the companies took place without reference to the board, the judge says, in brackets, although under the leadership of Mr. Brown, is also not inconsistent with this. That, again, must be right. Because directors do the things that directors are required and authorised to do. And people who get involved in the day-to-day affairs of the company don't thereby make themselves de facto directors. Because, as we'll see when we come on to vicarious liability, the only people authorised to perform any directorial function in relation to the claim companies were Mr. Brown and Ms. Lennon. Equity couldn't perform a directorial function, didn't purport to, and there was no need for it to purport to, because there were in place natural persons duly authorised to do the things that needed to be done at director level. 319 is a reprise of the advice point, the advice point on which the appellants seek to place so much weight. Buckingham was engaged, other professional advice was obtained by equity rather than by the individual claimant companies. But as the judge says at 319, this is consistent with equity's role as administrator. So there's nothing here that gets close to the plainly wrong threshold in my submission. 320, it's the hats phenomenon making an appearance, as it will again in vicarious liability. So Mr. Brown had two hats. When he did directorial things, he was wearing his director's hat. And it is in my submission incoherent to say that a de jure director who is an employee of an employer X, by doing things that he's authorised and indeed obliged to do as de jure director, makes X a de facto director. He just doesn't. And the judge really accepted that at 321, if my lords, my lady would read. It does make no sense, in my respect. We're just considering whether the judge, having regard to the totality of evidence, was perverse in his conclusion that equity was not a de facto director, and in my submission, it was not. Conclusion stated at 322. In my submission, that conclusion is unimpeachable. Having gone through the judgment, which I hope is a helpful exercise, in my submission it's a necessary exercise. We need to look at what the judge actually found and the basis for it. I'm sorry if it's painful at any point. But we return then to the familiar ground 23. So call 1, page 29. So sub 1, as we have just seen, all that the trial judge held at paragraph 315 was that based on the evidence he had heard and the documents he had read, the strategic proposals came from Buckingham and or Mr. Hallaby. The fact that Buckingham was acting as advisor to IMSR is nothing to the point for two reasons. First, it is immaterial to the judge's factual finding that strategic proposals came from Mr. Hallaby himself, i.e. not from equity. Second, the fact Buckingham was advising the Ironsdale Trust does not negate the fact established by the evidence as the trial judge found that Buckingham was, in addition to Mr. Hallaby, making the relevant strategic proposals. So one goes nowhere. Sub 2, well, yes, but I've already dealt with that in going through the judgment. Business below board level was conducted below board level without reference to the board. That does not make equity a de facto director. 3, well, yes, quite. It's a point against the appellants, as the trial judge rightly found. The Directorial Act was deciding whether to enter into a transaction when it was presented to the board. So, the fact that directors weren't coming up with the transactions doesn't mean they weren't being directors. They were being directors because they were deciding what transactions actually to enter into and on what terms. Four, conscious preference, no finding. So the same points that I made in relation to the shadow directorship question, mutatis mutandis, apply. It's just a bare assertion by the appellants. Even on their case, below, properly analysed, Mr. Brown's alleged actions did not further equity's interests, but rather exposed it to potential liability. Equity's trustee and trust administrator, it doesn't have a personal interest in, on the claimant's case, defrauding the revenue, quite the opposite. And as I said, in relation to shadow directorship, even if, and I stress this is not open to this court were to find Mr. Brown consciously preferred the interests of equity to those of the claimant companies, that conceptually and logically would not make equity a de facto director. The thing that would make equity a de facto director is if equity had done the things identified by Lady Justice Arden in Smithton. Having your interest preferred doesn't make you a de facto director. It makes you someone whose interests are preferred by a de jure director. Sub 5 I've already dealt with, but the appellants are in an even worse position on sub 5 regards de facto directorship than they are as regards shadow directorship, because as regards de facto directorship, the judge, as I've shown you, explicitly considers the effect of the advice having been given to equity and says it doesn't make equity a de facto director. And that reasoning is unimpeachable. Gave the factor weight. He was not perverse in the way he gave it. Sub 6 and 7 are only relevant to the shadow director question. I've dealt with them in that context and need not repeat what I said. For the reasons I've given, the judge's conclusion that equity was not a de facto director was far from perverse. I submit it was obviously right on the evidence and the facts as he found them. It was not based on or infected by any error of law. Again, it should be left undisturbed unless I can assist you further on the de facto and shadow director questions.
Thank you.
I'll move on then to vicarious liability. I'm grateful. My lords, it's necessary to begin by comparing and contrasting the grounds of appeal, grounds 20 to 22, with the actual terms of the judgment. It's also necessary to compare the grounds with the submissions that the appellants are trying to make. we say the argument they're trying to run now on vicarious liability is not open to them on the grounds. That doesn't mean I'm going to dodge the argument, but it's an important point. It's not a technical pleading point, as I'll show you. It's a thrust of the case point. The thrust of the case is nowhere in the grounds. What the grounds do on vicarious liability is make three misconceived and inaccurate isolated criticisms of the judgment. They're all bad, but even if they were all good, they would not enable this court to hold that equity was vicariously liable for Mr. Brown's alleged breaches of duty. The most they would do is open the door to a possible finding of vicarious liability, which is nowhere near good enough on this appeal. Even if the door were creaked open by the three grounds, it would be slammed shut by the judge's factual findings. And I'll endeavour to show your lordships your way to that as well. The unpleaded overarching argument that Mr. Parker made orally at the tail end of his submissions yesterday, and is foreshadowed to an extent in the skeleton, is that the trial judge erred in law by applying the decision of the Privy Council in Kuwait Asia Bank and following the decision of Mrs. Justice Dice, she was Julia Dice as she then was in Newey. Because such decisions are said to be inconsistent with what the appellants seek to characterise as the modern law of vicarious liability, which they seem to suggest was recently modified by the Supreme Court's decision in the BXB case. I will come to that unpleaded overarching argument in due course, in detail, but we say every limb of it is bad. To give you a prelude of my submissions in support of that contention, first, it's not open to appellants on their grounds, I've said that. Second, Kuwait Asia and Newey are not inconsistent with the modern law of vicarious liability. They form part of the modern law of vicarious liability, and they are entirely consistent with it. Third, BXB, which it bears remembering, was handed down after the trial judge in this case circulated a judgment in draft, and was not brought to his attention by the claimants, and did not relevantly change the law of vicarious liability, nor did it purport to do so. And I emphasise the word relevantly. It did make a couple of nuanced changes to the law, but they're immaterial to this case, as I'll show you when we look at BXB. It did not relevantly change the law of vicarious, modern law of vicarious liability. Fourth, the trial judge correctly identified the relevant principles governing vicarious liability and applied them to the facts as he found them. He made findings of fact which are unimpeachable, and then he made an evaluative judgment based on those facts, which is likewise unassailable. As I said when I began my submissions, with evaluative judgments, as you all well know, the same test of plainly wrong applies. In particular, the deputy judge identified the close connection test. That's limb 2 of the modern law of vicarious liability test. Modern law in the sense that it's the law as it has been since Lister in 2002. So the law as it has been without modification until BXB from 2002 is what we're talking about when we talk about the modern law of vicarious liability. And stage 1 is about employment, and obviously stage 1 is satisfied here. The satisfaction of stage 1 makes completely irrelevant, as Lord Reid emphasised in Cox and other decisions of the Supreme Court concerning vicarious liability. The satisfaction of the Lim 1 makes it completely irrelevant to consider Lim 1 factors in assessing Lim 2. Lim 2 is a freestanding question. Lim 2 is there a close connection between the employment-like relationship as found and the relevant wrong? The close connection test, as stated by Lord Tolson in Mohammed and Morrison, a horrible case about an assault of a customer of Morrison's supermarket by Morrison's employee, whose job it was to deal with complaints, and having been rude and racist in rejecting a complaint, followed the complainant customer into their car and assaulted them. A horrendous case. But for our purposes, the important thing is the close connection test was restated and affirmed by Lord Tilson. That was the case cited to the Deputy Judge below. It was the case applied by him. He, paragraph 274 of his judgment, we needn't turn it up, but page 148 refers to it, and he then goes on to apply it. He can hardly be criticised for failing to identify the slight modifications of the test that occurred in BXB, because they were immaterial to this case and they weren't drawn to his attention. I will come to Kuwait Asia in view of them. But the shortest of answers to the appellant's overarching argument, the point is nowhere in their grounds, is that the trial judge, having identified the close connection test, applied the close connection test. And we see that in the judgment at paragraph 290, page 151. You may as well have it. So I didn't think when I said we don't need to turn up paragraph 274 that I was about to take you to the judgment, but you may as well start with paragraph 274, which is at page 148.
Yeah.
My lord and my lady, I'm sure you're more familiar with these cases than I am, but Dubai Aluminium came hot on the heels of Lister, and we'll go to Dubai Aluminium. Lord Nichols in Dubai Aluminium was explaining Lister to a large degree, and one of the key points he made in Dubai Aluminium is close connection is a nebulous test. It depends on common law orthodoxy of looking at past cases and deriving guidance from them, and then applying that guidance. He said that a matter of months after Lister for the first time recognised the close connection test. The close connection test, as again you may well know, was developed in response to the horrendous sexual assault cases, because the idea of a sexual assault being in the course of someone's employment is itself offensive. And ideas like, oh, well, did the employment give the opportunity to commit the wrong, are too imprecise. So close connection was developed as a way of meeting that difficulty, and then there was uncertainty about it. But close connection having been recognised by the House of Lords in Lister, a few months later, Lord Nichols, again in the House of Lords, says, you need to look at the previous cases to apply that test. So he is absolutely not saying throw out cases pre-Lister. He's saying cherish cases pre-Lister. Identify the principles from them and apply them. Because there isn't a bright line division in the law of vicarious liability at Lister. Lister is a modest expansion of the very long established law of vicarious liability to recognise the close connection test, to deal with the kinds of appalling cases to which I've alluded. So Lord Nichols is saying, look at the previous cases. Kuwait Asia is, by a country mile, the leading relevant authority on this kind of question. That's the question that your ladyship have to consider. And the House of Lords, then the Supreme Court, has unbrokenly, for 22 years, because we'll see Lord Burrows says the same thing, been urging judges, look at the previous cases. Take guidance from them. So very far from, as the appellants seek to suggest, the Deputy Judge erring in having regard to an apex authority that predated Lister. He would have been erring if he hadn't done so. As the first instance tribunal, his mandatory task was to look at the previous cases, identify principles that could be derived from them, and then be guided by those principles, remembering that every case turns on its own facts. He was doing, once again, his job. I was just going to show you, having shown you 274, 290. We'll come back to the other parts of the judge's analysis of vicarious liability when we look at the grounds such as they are. 290, I say, my lady, is the judge applying the close connection test. When acting as a director, he, i.e. Mr. Brown, was no longer acting in the course of his employment with equity. Sorry, I'm missing out trust. An equity cannot therefore be vicariously liable for his actions in that capacity. As a matter of principle, I cannot see that this conclusion is different in circumstances where Mr. Brown consciously preferred the interests of equity trust to those of the companies of which he was a director. That is not, categorically not, that last sentence, an acceptance by the judge that Mr. Brown so consciously preferred equity's interests. And I'll make good that point in due course, but I'll show you where the judge addresses Mr. Parker's submission of conscious preference, and he rejects it, but then assumes its correctness in Mr. Parker's favour, and then rejects the legal argument based on that rejected factual assertion. That's what actually happened. So the grounds of appeal, tab 1, page 28 on this occasion. So at the bottom of the page, ground of appeal 20. So there is said to be an error of law by the judge. Not in the particular paragraph, but over 22 paragraphs. That an employer who appoints an employee as a director of a company could never, mark well, could never, be vicariously liable for the conduct of that employee when acting as a director of that company. That absolutist principle is nowhere stated in the judgment. It is an end to that ground of appeal to say that absolutist principle is nowhere identified in that judgment. Of the 22 paragraphs that the claimants put forward, 23, Mr. Norbury helpfully points out, one searches in vain for a statement of that absolutist principle, or indeed a principle that goes beyond guidance to be applied on fact-specific cases. But 289 it is perhaps as close as one gets. 289 read together with 290. So if we could go back to 151.
Page 151.
So page 151, I apologise, paragraph 289. if I might just invite my Lord Murray to read 289. Recognition of the dual function. I'll make some submissions once you've had the opportunity.
Yes.
So recognition, absolutely equity could be vicariously liable for things Mr. Brown did when he was doing non-directorial things in relation to the claimant companies. But when he was doing directorial things, on the facts as the judge found, he was no longer acting in the course of his employment with equity. That's not a general statement of principle. It's not an absolutist principle. It's a case-specific conclusion.
How do we know it's case-specific, not general?
Well, I will deal with that, if I may, when I deal with the overarching argument to make it good. Because the judge, as I'll show you, because I have to show you other parts of the judgment to my Lord Judge, to the whole court, in dealing with Uevend and Kuwait Asia. And you'll see that whilst he follows them, it's not a mechanistic application of them. He doesn't say, in Kuwait Asia, the Privy Council decided this on similar facts. In Uevend, Mr. Justice Dyes has decided this on similar facts. Therefore, I am bound to hold that equity isn't vicariously liable. So he's not purporting to identify any absolutist principle, or in my submission, any principle of general application. But as I'll come on to when I deal with the overarching argument, if there is a general principle, because it's not absolutist, it is right. The non-absolutist principle is that generally, or absent exceptional circumstances, where an employer has its employee be a director of a company within a structure that the employer administers, the prima facie position is that the employer will not be vicariously liable for breaches by the employee of duties that they owe as a director. It's a prima facie position, and it's not an absolute position. That is the proper analysis of the judge's approach to Uevend and Kuwait Asia, and my submission was entirely right. But again, not open to challenge on the grounds properly construed. So ground 20 is dead in the water, subject only to Kuwait Asia and Uevend having been wrongly decided.
And subject to your showing that the judge isn't stating a general principle.
Of course, yes, and sorry, and I will deal with those two together. I apologise. I meant to say to my Lord Justice Newey's point, and those two cases have been answered. Ground 21, my Lord. So back to page 28. So an error of law is asserted in ruling that equity could not be vicariously liable for Mr. Brown's breaches of fiduciary duty, even in circumstances in which Mr. Brown, to equity's knowledge, consciously preferred the interests of equity over those of the companies of which he was a director. In dealing with the de facto and shadow directorship points, I've said repeatedly, there was no finding that Mr. Brown consciously preferred equities interests to those of the claimant companies. So this point, it is not open to the appellants and goes nowhere. If we would turn back to 150, so page 150 in the judgment, looking at paragraph 284. Below, because the facts of Uevend and the facts of this case are in numerous ways strikingly similar. Uevend wasn't a fraud case, structures are incredibly similar. A point of distinction on the facts that's in equity's favour is that in evasion, employees were required as a term of their employment contract to take directorships of the companies, but even though they were obliged to do so, whereas Mr. Brown and Ms. Leonard were not so obliged. Mr. Justice Dice held Vistra, which was the trust company, was not vicariously liable for its employees' breaches of directors' duties. So naturally, we placed weight on evasion, and Mr. Parker, for the claimants, sought to distinguish it, as we see at 284. Mr. Parker submits the distinction in this case is the fact that the breach of duty is said to be fraudulent, and in particular, that Mr. Brown was knowingly acting not in the interest of the company of which he was a director, but in the interest of his employer, Equity, in its capacity as trustee of the Ironside Trust. The underlying principle in Mr. Parker's view for imposing vicarious liability where an employee acts as director of another company is that the employee consciously prefers the interest of their employer. That's what was being urged below. That's the principle, nowhere in the authorities. And then the judge doesn't reject that novel legal contention, but says even if this were right, the claimants cannot, in my view, succeed. The suggestion is that Mr. Brown consciously preferred the interests of the overall Ironside structure. Whilst Equity was the trustee of the Ironside Trusts, it did not stand to benefit in any way from the actions taken by Mr. Brown, even if they were taken with a view to promoting the interests of the Ironside structure.
Sorry, I've lost
Oh,
it.
I'm so sorry. I sped up and I should have slowed down. 285.
Yeah.
So
I see, yes.
even if this were right, so assuming in Mr. Parker's favour his novel legal contention is right, his modern law of vicarious liability is right, the suggestion is that Mr. Brown consciously preferred the interests of the overall Ironside structure. Whilst Equity Trust was the trustee of the Ironside Trusts, I emphasise these words, it did not stand to benefit in any way from the actions taken by Mr. Brown, even if they were taken with a view to promoting the interests of the Ironside structure rather than the claimant companies. That's why I said over and again, the judge rejected the suggestion that Mr. Brown, even assuming against him fraud, was through his fraud preferring Equity's interests to those of the claimant companies. He would have been preferring the interests of the Ironside structure, its beneficiaries, to those of the claimant companies. And as we say in our skeleton, on the appellant's analysis, which we say is wrong in law, that would have tended to make Mr. Hallaby vicariously liable for Mr. Brown's breaches of duties, if only Mr. Brown had been his employee or agent, but he wasn't. So he disposes of the conscious preference argument on the facts, on the evidence as he had it. So the premise of 21, ground 21, is bad. It is, in my respectful submission, not open to this court to hold that Mr. Brown consciously preferred the interests of Equity to those of the claimant companies. You haven't heard evidence from Mr. Brown. You haven't read all the documents. That would be disturbing the judge's finding in a way that is contrary to authority and principle. That is an end to ground 21. Ground 22.
You might also want to rely on paragraph 286, which ties it into what the beneficial interest of Equity Trust might be. That's just an extension. I'm very
grateful to my lady's assessment. I didn't labour the point, but absolutely 286 follows on from and reinforces 285. We're really in the realms of, was this rational, on whose interest would Mr. Brown have been preferring in a hypothetical world where Mr. Brown was guilty of the fraud that the judge acquitted him of. And the judge said he'd have been preferring the interests of essentially the beneficiaries, if I can say that as a shorthand, which is obviously right. You're not preferring the interests of a bare trustee when you give the beneficiaries a potential windfall and expose the bare trustee to potential criminal and civil liability.
I'm sorry, I stopped you. You going on to ground 22?
I wasn't ready, but I was very grateful for the intervention. But page 29. It's 286, by the way. So ground 22 attacks precisely the paragraph that my Lady Justice Asplin just highlighted as reinforcing my answer to ground 21. It is hopeless, ground 22, because paragraph 286 doesn't say anything like what the appellant suggests it says. The judge didn't say vicarious liability is excluded because equity's interests were held as trustee. He said nothing of the kind. Having held that, the close connection test wasn't satisfied, applying the principles identified in U of N and Create Asia. He had to deal with Mr. Parker's attempt to distinguish U of N on the basis of conscious preferring of interests of the employer. And he dispatched that first on the facts, no conscious preferring, and second, in what is essentially an evaluative judgment, which is the relevant interest that would be being preferred if Mr. Brown was preferring anyone's interests, are the interests of the structure and, as I use the shorthand again, the beneficiaries. That was all unimpeachable. But ground 22 tries to conjure up an absolutist principle where absolutely none was stated. And so I hope my Lord and my Lady will see why, subject to my Lord Justice Newey's point, on ground 20 alone, I said success on these grounds doesn't get the appellants where they need to be on vicarious liability. They also can't succeed on these grounds, and I will now address my Lord Justice Newey's point and the unpleaded overarching argument together, if I may. Unless my Lord and my Lady have any questions on the grounds themselves.
No, I don't detect any. Thank you.
So taking BXB then, which so I've been working digitally, but I think you're working from hard copy, is in volume 3, tab 15. The last tab of volume 3.
Tab 18, yes.
Tab 18, my ladies. And if you might turn to bundle page 756, page 971 of the report. It's important to emphasize, this is the hook, the peg, that the appellants hung their appeal on vicarious liability on in their PTA skeleton. They said BXB came out, Create Asia is inconsistent with the modern law of vicarious liability.
So this came out 2 days before judgment was handed down?
After the draft was circulated. Before,
yes.
And so that, in the PTA skeleton, they said Create Asia is inconsistent with the law of modern vicarious liability, see BXB, and now we look at BXB. Page 756. Lord Barrow's, having embarked on a characteristically thorough examination of the main 21st century decisions on vicarious liability at apex level, summarised pulled together the legal principles. 58. My lords, my lady, need not read all of those subparagraphs now. But what's important for present purposes is sub 3. So he's explaining the close connection test. He's really defining it. Whether the wrongful conduct was so closely connected with the acts that the tortfeasor was authorised to do, emphasise authorised to do, that it can fairly and properly be regarded as done by the tortfeasor while acting in the course of the tortfeasor's employment or quasi-employment. Just pausing there, the reason why, I mean, my lords, my lady will know why I emphasise the words authorised to do. Mr. Brown was not authorised to do anything as a director of the claimant companies in his employment by equity. The whole point was there was a separation in the structure. The things he was authorised to do as employee were administration and strategy. The things that he was not authorised to do as employee were directorial things. Because for the structure to be lawful, and authority is about what is lawfully authorised, for the structure to be lawful, he had to act independently in his directorial function. That's a key principle that we'll see from Kuwait Asia and U of N. So, as was said in Kuwait Asia and then repeated very recently by Mr. Justice Dyson in U of N, an employee director is acting unlawfully if they do what their employer says when they're executing directorial functions, or put their employer's interests above the interests of the company of which they are a director when they're performing directorial functions. So they're categorically not authorised to do anything directorial in their capacity as an employee.
It doesn't follow that they're not authorised to carry out their directorial duties properly.
No, my lord. They are authorised. The point is, they are mandated to disregard their duties as employee where carrying out their duties as director, except to the extent the two sets of duties are consistent.
What I'm putting to you is that does not mean that they are not authorised as part of the scope of their employment, not only to be appointed as a director, but to carry out their directorial duties properly.
Properly in the sense of diligently, man. I think that there's
properly in the sense
well,
of
and lawfully,
in accordance with the duties of a director.
Well, which means lawfully. And my lord, the only person who can give a director authority to do a thing on behalf of the company is the company. It's not the director's third-party employer. So when you talk about authority, the director employee is not authorised to cause the company to enter into a transaction in the course of their employment, because the employer doesn't have that authority to bestow. The employer can only authorise its employee to do things that the employer can lawfully do. And the employer cannot lawfully exercise directorial functions, and nor can it try to influence its employee to breach his or her duties as director, because that would also be unlawful. I'll return to that when we look at Kuwait Asia, if I may, my lord.
And so you're saying that the employer can say that you, my employee, may become a director of this or of that company, if that is permitted within your employment, the scope of your employment, and also could go as far as say you must always act properly and lawfully
Yes.
when acting in your capacity as a director, but that doesn't clothe the employee with anything qua director, because the clothes can only come from the company.
The clothes have to come from the company.
So it is an absolute principle.
Well, no, my lord, I'll come on to that, and it isn't. But my lord, that doesn't mean that I've thought of lots of exceptions to it. It's just important not to rule out exceptions, and we'll see that when we come to Liquidation and Newey event. One reason why, one possible reason why, other than my own inability, it may be difficult to think of exceptions, is that wherever the employer oversteps in such a way as to move from the prima facie position that I've explained pertains, they would almost always thereby attract liability on some other basis. So as de facto director, as shadow director, if they told the employee what to do, and the employee was accustomed to do what they were told, the employer would become liable as a shadow director.
But would they also become liable under the vicarious liability?
Obviously, in my submission, you need not decide that question on this case. And I would say, on one view, potentially yes, and then it's an exception to what would otherwise be an absolutist principle. Or on another view, no, because vicarious liability is a creature of policy, and there is no gap to fill. If an employer oversteps and acts as a shadow or de facto director,
they're still telling the director to do something which they can't authorise him to do qua employee, you would say, which is...
Well, then purporting to authorise might...
They may be purporting
yes.
to, but you say they can't.
No, but here there's no purporting to either, my lord. So,
I understand that,
yes.
I understand that, but just...
No,
I'm just looking at whether this is an absolute principle, because even in that overstepping the mark case, I think the essence of your earlier submission was that whatever the employer purports to authorise the director to do by way of his directorial functions, it simply has no capacity to give that authority to him qua employee.
Quite.
It wouldn't matter whether they were overstepping the mark or not. Vicarious liability couldn't attach.
Well, my lord, no, I did not go that far, partly because of my starting point, which is it is not an absolute principle. And from this discussion, my lord, I would say that if liability was possible in an overstepping case on two bases, i.e. de facto or shadow director and vicarious liability, that would go to reinforce my point that it isn't an absolutist rule.
I mean, one problem with that analysis is that certainly for shadow directorship, but arguably for de facto directorship, you require more than a one-off incident.
Yes.
So that's not quite meeting my lord's point, is it? If the employer on a one-off occasion intervenes, shadow or de facto directorship won't really help.
No.
There's still a debate as to the policy, whether in those circumstances the employer should be liable, but that's a different point.
That, my lord, might be an example par excellence of an exception to what I've described as the non-absolutist prima facie position. Because if the employer purports to authorise its employee to do a certain thing, or purports to direct or instruct it to do a certain thing, let's use direct and instruct because that's the wording for shadow director. So it purports to direct or instruct its employee, which it knows is an unlawful thing to do, because the employer necessarily knows that's unlawful because it's instructing a director to break their duties.
Because if it did that dishonestly, you'd be into dishonest.
Of course, or conspiracy or any other. But,
yes.
but my lord, when I say it knows that a director is meant to be independent. It's purporting to tell the director, do this thing, where the director's only lawful response is, I'll do what I think is best for the company. There, one can absolutely see a principal basis for imposing vicarious liability on the employer. Because of the purported instruction, or in fact, well, it's a real instruction that the director should disregard. But if the director complies with the instruction, then one can see a principal basis for vicarious liability. But that wasn't this case, because the judge found that Mr. Brown did not act on instructions. He and Miss Leonard exercised their independent minds.
When you come back to accepting the first proposition that I put to you at the start of this discussion, that an employer can authorise a director to do something in performing his directorial functions.
Well, it depends on how one conceptualises the word authority in that context, my lord. In my submission, an employer absolutely can direct or instruct, but the only person, I repeat, I think we're just talking about different types of authorising, because I said the only person who can authorise a director to do a thing qua director is the company. The employer can authorise an employee to do something. That doesn't, as my Lady Just Asplin said, clothe the employee with any ability to do that thing.
In that, are you using authorise in the sense of empower, confer the legal power to? Plainly the employer can't confer the legal power.
Yes.
But is that the same thing as authorising?
No, it's different, but I'm using it to illustrate that where there's a separation of functions, I repeat the submission I made earlier, there's a prima facie position that the employer is not vicariously liable. And we'll see from Kuwait Asia and UofN, lots of things don't suffice to move from that prima facie position. I was saying my submission has always been on the basis that there may be some things that do move from that prima facie position. And from this exchange, I would say a thing that could move from that prima facie position is an instruction by the employer to its employee to do a thing qua director.
Is the consequence of that when we look back to the language in paragraph 58(3), what's meant by authorised in that paragraph is not clothing with legal power to do, but purporting to act on behalf of, or something looser. Because if I thought your initial submission was it means clothing with legal power to, and that would lead, as I understood it, to the absolutist position which you draw back from, and that if you can come within that test, if you do something which you don't as an employer, which you don't have the legal power to confer power to, you don't have the ability to confer legal power to do, but you purport to do, then that could become within the vicarious liability principle.
It could come.
So authorised doesn't here mean
empowered to
give legal power to.
No, it does not mean that, my lord. But I was emphasising the word authorised in the context of what is an importantly longer sentence. Authorised to do that, it can fairly and properly be regarded as done by the tortfeasor while acting in the course of the tortfeasor's employment or quasi-employment. So, the reason why it's my fault, but the reason why we got into what an employer can and can't authorise in the sense of empower an employee to do was that an employee doing something which they absolutely don't have power to do because their employer told them to do it, in my submission, can't be fairly and properly characterised as being done in the course of their employment, having been authorised.
But if you can fall within the scope of that test, if you authorise someone to do something contrary to their lawful duties as a director, why can't you fall within that test by authorising someone to perform their duties lawfully as a director? And if you can do the latter, then isn't the question whether you are employed, or whether it's within the scope of your employment simply to be appointed a director, or whether it's within the scope of your employment to be appointed and to carry out your duties as a director?
My lord, I accept that. I've said all along, it's not an absolutist principle. I think we do need to look at Kuwait Asia and UofN to see what the Privy Council and Justice said. The critical point in their analysis is one that I've already alluded to, which is that the reason why it's not in the course of your employment to perform the duties is that wherever there's a conflict between your employer and your duties as director, so employer and company, the only lawful course is to prefer the interests of the company and to prioritise your duties to the company. So for the structure to work as a matter of law and to give effect as a matter of policy to the doctrine of separate personality, there needs to be a dividing line absent exceptional circumstances. And the exceptional circumstance could be instructing the employer to do something which they can't lawfully do as director. But there needs to be a dividing line. Vicarious liability is all about the closeness of the connection, and the connection is not broken by the fact of the employee being director of the company. It is just very substantially weakened. If it's broken, it would be an absolutist principle. It's very substantially weakened. And it may then be strengthened by acts of either the employer or the employee. That's the way that, in my submission, that the analysis works.
Thank you.
And then at 4, sorry, my lord, at sub 3, you'll see that Lord Burrows says the test that he formulates is the test subject to 2 minor adjustments set out by Lord Nicholas and Dubai. Just the same, it's the test that just has applied, and Dubai Aluminium was itself drawing on Lister. And then the adjustment says, my lords, my lady will see, do not affect this case. And then over the page sub 4, I wish to emphasise the test and legal principles. Then the vast majority of cases can be applied without considering the underlying policy justification for vicarious liability. Policy is a check at the end, as Mr. Parker submitted yesterday. One takes guidance from the cases, as I have said, my lords, my lady. If you might take Authorities Bundle 1.
Just before you do, that last bit of 4, where we get the core idea, if you think about the core idea, where does that take you in circumstances such as those in the present case? I mean, was Equity Trust taking the benefit of Mr. Brown's activities?
No.
Such that Equity Trust should bear the cost?
My lord, absolutely not, as per the judge's findings, that the person who was getting the benefit were the beneficiaries of the INSR structure. It was their interests that were being...
It was allowing Equity Trust to perform its functions.
It was allowing Equity Trust to be administrator.
For which it doubtless got paid.
It got paid to be administrator. But the person benefiting from performance by Mr. Brown and Mr. Leonard of their duties, the person who was ultimately interested in the success of the company.
Well, it might be said more generally that Equity's business was to run structures in this way, and part of its business was to provide to its various clients special corporate vehicles to act within the trust structure and to provide its employees to be directors and to carry out their functions as directors for those companies. And that was all part of Equity's business.
My lord, yes, it might. But if that were the analysis, and if that led to the conclusion that a trust administration company was always vicariously liable for breaches of duty by its employee directors of companies within trust structures, that would be a very, very strong thing.
Well, I understand that. I understand that. But that does seem to fall within the the policy reasons that Lord Reed has identified there, or Burrows has identified from Lord Reed.
Policy isn't the starting point.
It isn't the starting
It's a
point.
check at the end, and the starting point is the closeness of the connection, and then you look at the previous cases and say, what principles can we derive from those previous cases? So this court's function, with the greatest respect, is not to think afresh what policy considerations should govern trust administration structures and turn that world on its head. It is to say, well, first of all, it's to look at the grounds and say the grounds aren't laid out and say the appeal fails. Then it's to say, if it's interested in the overarching argument, well, the judge's analysis didn't involve any absolutist principle. It involved an orthodox approach, in fact, a mandatory approach to the authorities, and it was a proper evaluative judgment that we're going to leave undisturbed. So my Lord might think that the law should radically change, and then not just in this jurisdiction, but every jurisdiction where there are trusts, there will be great consequences. That's not a reason not to change the law. But
it could be, of course.
It could be, of course, but it's when you're talking about policy, I'm, of course, I'll leave it there. It would be a very strong. It would be a very
I
strong.
understand where this goes in terms of its ramifications.
Yes, and you don't start from policy and then reason backwards. My Lord, I was going to take you to Dubai Aluminium, but I'll just give you the reference in view of the time. So it's tab 7 at page 175. It's in Lord Nichols's judgment.
Sorry, tab 7 page.
175. Just to emphasise the need for guidance from the cases. And if you are turning it, we probably do have time to turn it up. It's also makes good my point that the court is making an evaluative judgment.
Yes.
So at paragraph 26.
Yeah, speaking for myself, I find that helpful because the level of generality of the test
My Lord, yes.
does not readily give you the answer in all cases. As the divergent decisions in relation to sexual abuse or physical abuse show.
Absolutely, my Lord. Well, I'm glad that was helpful because that's one starts with that. If policy was the starting point, if policy governed all, pity the first instance judge. The first
It's not
I
just
slightly
policy.
do pity the first instance judge in this area.
But Lord Nichols makes that point, my Lord, too. But the first instance judge looks at the cases, applies the case connection test, and does the best they can, and it's an evaluative judgment, and the Court of Appeal should be very slow to interfere with it.
It's not just policy, it's the test. The test as formulated by the Supreme Court is itself put at a level of generality,
Yes.
which doesn't necessarily give the answer, obviously,
No.
to any given fact.
No, it doesn't, of course. When you have a decision of the Privy Council that stood for 30 years, it's a good place to start. And so let's go to that. It's in bundle 1, tab 1. As my lords, my lady know, the case involved a claim against a bank on the basis it was vicariously liable for the acts of 2 employees, which had been appointed directors of a subsidiary company. The Privy Council held that the bank was not vicariously liable on the basis that if the directors breached their duties imposed on the directors of the company, they did so in their capacity as directors of the company or as individuals, not in their capacity as employees of the bank. And the key passage is at 222C of the report, page 40 of the bundle. beginning just above letter C, if House and August committed a breach of the duty which was imposed on them.
Yes.
It didn't bind the judge. He didn't act as though it bound him. It is highly persuasive authority. It identifies principles that could not be more obviously applicable to the present case. It is not made anachronistic by Lister. It's exactly the sort of case to which judges are urged by Lord Nichols to have regard, and we'll come to Mr. Justice Dias analysing it in a more recent context. At letter E, just above letter E, in the performance of their duties as directors and the performance of their duties imposed by the trustee, ignore that, House and August were bound to ignore the interests and wishes of their employer. They could not plead any instruction from the bank as an excuse for breach of their duties to AICS, the employer and the plaintiff. Of course, if the bank exploited its position as employers of House and August to obtain an improper advantage for the bank, which was harm to the plaintiff, then the bank would be liable for its own misconduct. That's really what I was getting at in one of my exchanges with my Lord Justice Popplewell. The bank might be liable for overstepping. In other words, it might attract direct liability. But the Privy Council seems to analyse it as, but the bank wouldn't become vicariously liable even if it tried to exploit its influence over its employees. The bank had a duty to refrain from exploiting its influence over its employees, no different in principle from the duty of a father not to exploit his influence over a son who's director. The employment of House and August could have given the bank the opportunity to injure AICS and the plaintiff, but that did not make the bank responsible. Opportunity to injure just was debunked as the test before Kuwait Asia. So, my Lord, that's the principled analysis of the Privy Council, and set against it, my learned friends say, well, there's academic criticism of Kuwait Asia in one Australian textbook in 1997. And if you have the time to look at it, it's at the back of the authorities bundle. The criticisms are anachronistic. The criticisms on the basis that House and August couldn't be said to have been acting on a frolic of their own. It's just nothing to do with the close connection test. So you can disregard the criticism safely, and a judge of a different jurisdiction criticising the Privy Council 30 odd years ago doesn't really move the dial in my submission. Professor Poole's case comment described the decision as not surprising, and explains the case comments also in the bundle should you wish to see it, and explains the reasons for her view of it. Perhaps more important, Boasted and Reynolds still cites it without negative comment or any qualification as authority for the proposition that an employer is not vicariously liable for breaches by their employee duties that they owe as a director. So to say academic criticism and then bring out a wild textbook is putting things rather high. Where, as I'm sure my Lords, my Lady will have seen, when Mr. Parker says, oh, but it's not been followed by the Privy Council, the Privy Council hasn't chosen not to follow it either. The Privy Council has, in one case, in the New Zealand Guardian case, looked at one obiter remark that is no part of the ratio and said, not quite sure what was going on there, and gone nowhere near disapproving Kuwait Asia. So the remark that is disapproved in New Zealand Guardian is on letter B on the same page. It's this slightly gnomic statement: the bank was not responsible for a breach of the duties owed by House and August to AICS or to the plaintiff, any more than AICS or the plaintiff are responsible for a breach of duty by House and August.
Sorry, where are you
So
reading
letter
from?
B. It's that particular
ICS. Yes.
line. So that's the line that is disapproved. No other part of the decision. And where the Privy Council is taking issue with an isolated obiter remark in a decision, if it disapproves of that decision more generally, it does not tend to be shy in saying so. Dealing there with the appellant's point at paragraph 81 of their skeleton, in reliance on Lord Keith's in passing comment in New Zealand Guardian Trust. So Kuwait Asia has stood as good law for 3 decades and was followed by Ms. Julia Dias QC, as she then was, in Uevend. If we might turn to that. Tab 16 of the authorities bundle at page 702. So it's going to be bundle 3. And my lords, my lady, have it. I wanted to take you first to paragraph 57 to show you the learned judge said the case before her seemed to her virtually indistinguishable from that which pertained in Kuwait Asia. And she explains that case in some detail. If I might invite my lords, my lady, then to take up the decision at paragraph 70. I should pause just to say, of course you're not bound by Uevend, but Uevend was a case applying a venerable Privy Council decision, consistent principles from it, and the judge below had regard to those principles in making the evaluative judgment that he did, and that's a further reason why you should leave undisturbed his evaluative judgment. So at paragraph 70, the judge rejects. I'm doing my Lord Justice Popplewell a disservice to describe it as Lord Justice Popplewell's argument, but the argument that just because they were employed and required to be directors, their employer was vicariously liable. She rejects that argument explicitly by reference to the Morrison close connection test. Final sentence. In my judgment, the mere fact that their employment provided the opportunity for them to be appointed as directors comes nowhere near establishing such a connection. So, if you're going to entertain the unpleaded overarching argument, then Kuwait Asia has to be wrong, Uevend has to be wrong, and then the judge's only error was applying 2 cases that have never been doubted by any other judge. If you might just read on, you may be reading on to paragraph 74, and then I'll make a couple of submissions. I've asked you to stop at 74 because there's then a discussion of a comfort letter that was just unique to that case.
Yeah.
The close connection test isn't straightforward because of the 2-hat problem and the absence of Chinese walls. Very strikingly analogous to the present case in terms of the the role that Vistra had strategically and administratively. Then 78 over the page is the judge's conclusion. There was a separation of function between Mr. Ng and Ms. Lin exercising high-level oversight on behalf of Vistra as trustee, and Mr. Ng and Ms. Lin acting as directors of Asplin. And then 79 is key. It's the point that I made to my Lord Justice Popplewell. When an employee director is doing directorial things, and the judge said particularly corporate acts such as signing documents, they were prima facie carried out solely on behalf of that. She does not articulate an absolute principle. That's where I got prima facie from. Prima facie. And she makes the point they had no power. This is authorised in the sense of empowered to do any directorial thing other than as a director. So that's her reasoning. And then at 80, for the claimants, Mr. McCormick, QC, argued that where there was a deliberate structure to with inherent risk of confusion, Vistra Singapore should reap what it had sown. And at 81, the judge rejects that argument. Again, identifying estoppel as a potential way of having Vistra be liable on the facts of that case, but not vicarious liability. It says, on vicarious liability, the critical question is the capacity in which Mr. Ng and Ms. Lin were in fact acting and carrying out relevant acts.
And the second half of 81 does recognise that there might have been other factual circumstances in which there could have been dual capacity.
Indeed.
Wearing both hats at once.
And my Lord, I know you will have the point. Kuwait Asia itself recognises the possibility of a fraud exception, i.e. where the employer is being fraudulent. It might be liable. But there's no, here in our case, the only person who's alleged to have been fraudulent is Mr. Brown himself. So there's no fraud alleged against anyone else acting as a natural person through whom equity as employer told Mr. Brown to do things.
The validity of this argument must hold good irrespective of fraud. It would apply to a negligent breach of Mr. Brown's duties.
What's in the integrity, my Lord, is that it's, when we talk about the integrity, we come back to the point that it's not absolutist as a principle. She talks about prima facie. What can move from the prima facie position? And I say fraud by the employer could, inappropriate or unlawful purported instruction by the employer could, and other types of missteps, as I've explained, missteps by the employer, oversights by the employer, could attract liability on the employer's part on different bases. So my Lord, I think I only have one more minute left, so...
Sorry, I've slowed you down.
Sorry?
I've slowed you down.
Oh, no, well, in injury time, my Lord, the principles that are to be distilled from U of N and Kuwait Asia, and which the judge was guided by, are first that where you're in a dual hat or dual capacity case, the critical question in applying the close connection test is what capacity the director was acting in carrying out the relevant acts. And one gets that from the extract of Kuwait Asia that I took you to, and from U of N at paragraphs 49 and 81. The second principle is that where the director is performing their duties and functions as a director, prima facie, they'd be doing so only in their capacity as director and not acting in the course of their employment. And the third point is, while certain factual findings may justify departure from the prima facie position, the following factors will not suffice. A, the fact that employment by the company that employed the director provided them with opportunity to become a director, or even was the reason they became the director. B, the fact that the director's activities were carried out on their employer's time and or at their employer's expense. And that comes back to my Lord Justice Popplewell's point about the policy, but that's to approach the question from the wrong end of the telescope in my submission. So Kuwait Asia at 222B, U of N at paragraph 70 makes clear that on the employer's time or for the employer's financial benefit is not enough. And C, the fact that the employee director might have taken into account his employer's wishes to the extent that they did not conflict with the company's interests also is not sufficient. That's U of N at 69. Stepping back at the risk of labouring the point, the judge identified the close connection test and made findings of fact. With a careful survey of U of N and Kuwait Asia, he made an evaluative judgment. You should not disturb it. And also, the overarching argument is not open to the appellants, unless I can assist you.
No, thank you very much. Mr. Parker.
Lord and Lady, I've taken the liberty of writing down my response to Mr. Norbury's submissions in respect of Mr. Brown's liability, which I hope will speed things along. And the note begins by setting out.
Has Mr. Norbury seen this before?
He has not. Well, it was prepared at 2 o'clock, by 2 o'clock.
Wasn't it handed to him at lunchtime?
Strictly, it might be said it's your reply, and he had no right to know what your reply was going to be.
Well, I'm sorry if I've erred. I did rather think that he's, along the lines of Lord Justice News very helpfully said, I'll be saying very plainly, go along. The concessions that I've set out here are all by reference to documents. I'm saying insofar as Mr. Norbury raised a point of contention about what I thought had been a concession, and we've dealt with that. But in the course of a debate over the 3 days, there have been various references to what's been conceded and what might not have been conceded. So I thought it might be helpful to draw those to your attention. So first of all, concessions in respect of quantum of loss. Then there's a concession in respect of knowledge, including blind eye knowledge with respect to it being a dividend and an unlawful distribution being incapable of ratification. It's one of the topics the subject of exchange with Lord Justice Newey. As I say, knowledge included blind eye knowledge, and then repetition of unlawful dividend can't be ratified. The concession that committing a tax fraud is breach of fiduciary duty that Mr. Norbury reiterated yesterday is there by reference to the trial bundle. And then the acceptance that Mr. Norbury referred to, took issue with this morning. We'd relied on 180 as being accepting that if Mr. Brown had blind eye knowledge of the transfer of Newcourt being entered undervalued, that in those circumstances it was dishonest by reference to paragraph 180. And we note in the footnote that in opening it was said that it was necessary but not sufficient, and the words not sufficient have been removed from the closing. So we understood it to be a concession. I said it was an acceptance during my oral submissions in closing, and that wasn't challenged. And what we say about Malone & Friends' reliance upon 190 from this morning is we say, well, that doesn't add anything because it's supported by what Mr. Brown said in his evidence, and Mr. Brown, of course, was not accepting that he'd had any knowledge with respect to an undervalue. What we say 190 is referring to the possibility of HMR challenging the transfer at 65 million. which would have given rise to a tax liability for which no provision had been made. It's not discussing the situation of Mr. Brown having blind eye knowledge of the transfer having been at an undervalue.
My lords, my lady, may I just make rise to make one submission? The general practice is that in reply submissions, if my learned friend says something I don't agree with, because he's given oral submissions, I have the opportunity to harumph or say something. Because my learned friend is whizzing through very dense written submissions, it is simply impossible for me to take any stance on this. Some of this may well be correct and uncontroversial. I suspect a lot of it is incorrect, at least on our case. So I merely observe that the production at the last moment of an additional round of written submissions is unfair.
Can we just talk through it for a moment?
Of course, my lord.
In principle, you're not entitled to notice of reply submissions. Someone in reply can say what they want to. The nature of reply submissions is such that they have to be in reply. Absent a reference to, say, a new authority, provided the submissions are in reply, the respondent gets no last word. Now, you say in these particular facts, because this document has only arrived at the last moment and you haven't had a chance to digest it properly, there may be some particular point that you would think you were entitled to respond on, which you may not be able adequately to identify now.
Absolutely.
Can we think about that at the end of Mr. Parker's submissions? I mean, if there were a concern of that kind, it may be that we would want to give you some very, very limited opportunity to put in some document simply dealing with those points, but I'm not sure we're there yet.
I'm very grateful.
I find it slightly odd because I could just read it out, but it's only a point.
But you're not reading it out. Yes, it's full of footnotes which purport to justify matters that you assert are common ground, which you wouldn't take us to in reply because you wouldn't have time to. And if you simply asserted that they were common ground, then speaking for myself, Mr. Norbury would be entitled to jump up and say, my learned friend says that's common ground, but it's not.
Well, I'll accept that, but I thought this facilitate the matter.
I don't want to take up your time. I'm very happy. I'm very happy that.
I apologise if I've erred. I apologise if I've erred by writing it down.
Perhaps it's best if you just start from where it says reply submissions.
I'm sorry, lady.
I said perhaps it's best if you just start from where it says reply submissions on page 3.
Well, I was endeavouring to assist in terms of the previous discussion, but if we go to reply submissions, we say paragraph 9, the relevance of the practice direction of witness statements, that's not understood in circumstances where the witness statement accorded with the pleaded defence, which set out the critical issues. Now, my learned friend sought to say that our position was was incoherent with respect to Buckingham. You recall he said that I put to him, with reference to Sampson House, that he'd said that he'd relied on Buckingham. Now, what we say is our position is not at all inconsistent. I was putting to Mr. Brown his previous inconsistent statement in the Agelman's proceedings relating to the transfer of Sampson House, that he did not in fact obtain independent valuations that he'd said he'd known he needed to obtain, and which was said to be the basis for his pleaded belief that he believed the transfer prices were equal to the market values. Now, the complaint for this appeal is based on the factual position that for both properties in this claim, Mr. Brown continued to say that he'd known that he needed an independent valuation and that he'd obtained one, and that's recognised in the judgment. So whilst Mr. Brown was saying that he might in fact for Sampson House, but not Ludgate House, I've just relied on valuation advice from Buckingham. He never said that he believed that the transfer prices for New Court or Ludgate House were the market values based on advice from Buckingham. On the appellant's content, the judge did not find that he had so find. But if the judge did, as the respondent's content, it's important to appreciate we were not saying, of course, Mr. Brown just thought these figures of himself. What we're saying is, given that he'd said he needed independent valuations in order to know what the market values were, it didn't really matter where he got the figures from, unless he'd got them from independent valuations. So we were pointing out, in the context of Sampson House, contrary to his pleaded defence that he needed and had obtained independent valuations, we were pointing out he said he'd got them from Buckingham. It's not an incoherent position of the appellants at all. And then Mr. Norbury took you to part of the cross-examination, which I've referred to, whereby Mr. Brown was introducing Buckingham in response to my questioning about independent valuations. By reference to it depended on the circumstances, and it was all a bit confused as to what his position was. But then the judge intervened to ask him, in the circumstances of this case, the circumstances of a hive-up, what did you need? And he clearly said, I'd have to get an independent valuation. And thereafter, he was clear. Because it's a hive-up, I'd need an independent valuation. So the position was that Mr. Brown's evidence was always in accordance with his defence. And we say that is why, when we come on to Malone and Friends' submissions about the pleadings, the important thing is his submissions ignore the fact that Mr. Brown was saying that he knew at the time that he needed a valuation, clarified in the witness statement as an independent valuation, and that he knew one was necessary.
But why does any unfairness to you arise in this context? It is apparent, isn't it, that before the trial, certainly in opening, Mr. Norbury was making clear that the defence wasn't limited to that particular way of putting it. And you knew that before you cross-examined Mr. Brown, and there was no other witness of fact. So why isn't it fair to let the case be approached on the wider basis?
Well, my lord, because we, in my submission, what Mr. Norbury's particular point, first of all, Mr. Norbury's particular point was simply about the pleading of the basis for the belief. Now, we say in the pleadings, it said paragraph 14. That's paragraph 27, subparagraph 2 refers to paragraph 14. Specifically says his belief, this is 49, subparagraph 2, was based on the independent valuation. Now, he was saying, we don't want to be bound by that. Well, what else are you saying?
But where's the unfairness to you? You know that's his position. You know that before you do your cross-examination. There's no suggestion that you limited your cross-examination because Mr. Norbury had represented that he was only relying on this one way of putting it. So why is it unfair? It's
unfair if you go. It's what Mr. Norbury say what he wants. And Mr. Norbury was basically, but Mr. Norbury was inviting the judge because he wasn't putting forward any positive case. He wasn't saying we've got some other reasons. He was just saying, forget what we've said in paragraph 14 and do your own thing. And the judge went off and did his own thing. And in the course of that, the judge disregarded paragraph 14, which there'd been no attempt to amend.
But where's the unfairness to you in any of this?
Well,
what would you have done differently?
It's not so much an unfairness point. Well, I think what we would have done differently if there had been evidence along the lines of not having obtained a valuation is we would have asked him why he didn't obtain a valuation when he was accepting in his pleadings and in his witness statement that he knew he needed to obtain one. So
You surely did ask him. I haven't been through looking carefully, but you must have asked him about the absence of evaluation and why one wasn't obtained.
Well, because the answer is always, but I got one.
Yeah.
Everything comes back to saying, I got one. And that means we can't investigate these other things, nor should we have to, because he's admitting and continues to admit that he knew he needed a valuation.
But how long?
Well, the fairness isn't so much in the conduct of the case, it's in the judgment that's given following that.
That's not really a pleading point. You say, well, in this respect, you would be saying there was no evidence to support the conclusion.
The fundamental point is I was not exploring with the witness the fact that he needed a valuation, because he was admitting he needed a valuation. Now, if his pleading had been, and indeed this is the point we can make at paragraph 69 in my learned friend's closing, his submissions are based on a valuation being desirable but not essential. If that had been the case, there would have been cross-examination based on the fact that Mr. Brown must have known that a transaction of this sort, with all the advice he had received from solicitors, required an independent valuation. None of that happened because his pleaded case was always, I was aware I needed a valuation. And I repeat, he never ever resiled from that in the witness box.
Because, see, on the basis that the judge concluded that Mr. Brown was unreliable but not dishonest, he didn't resile from it because that was his flawed recollection. I mean, that's the trouble with asking a witness to give evidence so long after the event.
Well, it's not asking it. In his case, they say he's got lawyers. In his cases, you don't. The case that's put forward in response is an admission. He puts it forward as benefit lawyers. Mr. Parker, at trial, you will not need to investigate with me, Mr. Brown, the importance of obtaining an independent valuation because that's admitted. And it's not a case of like, oh, well, this all came out in cross-examination, etc. No, he said that from the start and he stuck with it. So that's two things I never went anywhere in cross-examination because I didn't need to because they were admitted. He knew he needed it to get a valuation, which he was saying was an independent valuation, with no suggestion that that was simply desirable and I could have relied on something from Buckingham. The second thing is, I didn't cross-examination about his understanding of the terms of the representation that was to be made to HMRC, because that was also admitted. Therefore, it's entirely wrong for the judge to say, well, I'm going to ignore the fact of that admission and I'm going to proceed just simply to look to see what it is Mr. Brown did and then not then assess what he did against the admission that he knew he needed to get an independent valuation. And also, as we say, not actually to look whether Mr. Brown ever said in his witness evidence that he believed that the transfer prices were the market value based on what Buckingham had said. And indeed, and this wasn't a particularly rational distinction, but in the witness box, Mr. Brown was saying, well, whatever happened on Sampson for Ludgate House, I knew I needed an evaluation and would have obtained one. And that's why we say, Mr. Norbury sort of saying, well, we wanted to leave it to the judge on the belief, doesn't get him where he needs to be, because the problem is still the admission with respect to the need, and he's not offering any alternative case. And the draft list of issues point, well, we say, look, we put forward a draft list of issues. We weren't on notice that they wanted to do anything other than in their pleadings, so we can't be prejudiced by that. All we say is that when this dispute came to a head, we were saying, well, no, we want to hold you to your pleadings. But I repeat, none of this was actually in any way seeking to row back in terms of withdrawing admissions from paragraph 14. And I say, Mr. Norbury, to my mind, mischaracterised the nature of the dispute, because we're not saying there was an admission of dishonesty, we're just saying there's an admission that he knew he needed to obtain independent valuations. He knew that. So the question arises, why didn't he get one? And that's the other unfairness. The judge never gets to grips with the blind eye knowledge on the basis of Mr. Brown's admission that he knew he needed to get an independent valuation, consistent with his case being that he had got one. And that obviously raises the question, why didn't Mr. Brown do the very simple thing of having the property valued, which he knew he needed to do? That question is never asked, because we've just slidden away from the pleadings in circumstances where this hadn't been investigated in cross-examination because it was an admission. And the reason, and we say, yes, no admission of dishonesty, but what we're concerned with is, what did Mr. Brown know? What did he know at the time? What did he know and what did he do? And the admissions went to, what did he know? He knew he needed an independent valuation. He knew the representations, the terms of the representations that were going to be made to HMRC. And that's why we say, when one looks at Hayes and Palumbo, once you haven't got the independent valuations, and you haven't got Mr. Brown saying that he relied on anything else for his alleged belief, because he knows what the terms of the representations are to be, Hayes and Palumbo leads to the conclusion that it's dishonesty. And what was the particular point that I may have misunderstood, and I may be being overly careful on this, Lord Justice Popplewell highlighted that what was put to the jury in the Hayes case was the item 9, whether Mr. Hayes appreciated that what he did was dishonest by the ordinary standards of the ordinary people, words to that effect. And of course, that was put to the jury because Mr. Hayes was being trialled under the old 2-stage test of dishonesty of re gauche, not Ivy and Genting. Now, if you know, which is what Mr. Brown was admitting, that the representation to be made is your honest and genuine assessment of this as the market value, and if you're not then putting forward your honest and genuine assessment, because Hayes and Palumbo says you can't choose from a range influenced by commercial advantages, then we say it follows, applying an Ivy and Genting test, that he was dishonest. So it's not a direct admission of dishonesty, but we say it follows from the admitted facts that once he didn't get an independent valuation, that he was dishonest. We say that Mr. Norbury's approach of looking at Ludgate House before he looked at New Court, that was rather odd, because it's wrong to start with the more truncated reasoning as applied to Ludgate House, and then try and impose that on the analysis for New Court, which was fuller. We say the judgment should be read in the order it was written. And then the suggestion that we're simply speculating that Mr. Sirra and Mr. Pollard's awareness of how the transfer prices were set, we're speculating that was also Mr. Brown's knowledge. But we say that's simply not right. The judgment clearly proceeds on the basis that the awareness of Mr. Sirra and Mr. Pollard is communicated to Mr. Brown. And indeed, the conclusion at 251 that we there highlight, the conclusion to this particular passage, if we turn it up, 215, 251, has the discussions, Mr. Brown discussing this with Mr. Sirra, discussing with Mr. Pollard, informed him of discussions of Mr. Sirra and S.J. Bowen. We've looked at those. And then we say, well, what we'd say is that if the judge was intending to suggest that Mr. Brown's understanding was different to that of Mr. Sirra and Mr. Pollard, he would have said so. And that is why at 251, he doesn't say, the judge does not say that it can be inferred that Mr. Brown believed that the market value of Ludgate House was 78 million. He says it cannot be inferred that he knew it was in excess of 78 million. That's because when one's using a justifiable figure from a range, you don't know that some other figure is the correct figure, consistent with the way it's expressed at 251, but you also do not believe that that figure is the market value. And we point out that Mr. Norbury's reliance on paragraph 248 on the use of the word justifies should perhaps be seen in the context of the submission that was made in the respondent's written closing at paragraph 253, that 78 million is, quote, a justifiable value of Ludgate House as at the 1st of August. The S.J. Bowen letter, again, points arising from Mr. Norbury's submissions. No suggestion at the trial that Mr. Brown was honest, just because he relied on the advice of S.J. Bowen. For the judge, we note, the advice at the conference call with Mr. Sirra and Mr. Pollard was the same as in the letter, and that advice informed Mr. Sirra's advice that 78 million was an appropriate market value to use for the purpose of the sale to Ludgate properties, which advice the judge held was relayed to Mr. Brown, that we saw in paragraph 250. And there's no suggestion at trial that Mr. Sirra's view or understanding as to the basis on which the transfer price for Ludgate House had been set was any different from Mr. Brown's. And we say it is clear from the judgment at 241-244 that the judge is treating Mr. Brown's understanding as to the basis for the transfer price as being a product of the S.J. Bowen letter and conference call. And we highlight 126 when the judge deals with the accounts. Remember the accounts that said had the property in at 65 million, but had a statement that if the property were to be valued, the value would be in excess of 65 million. There's no distinction drawn there between Mr. Sirra and Mr. Brown. Then moving on to Mr. Norbury's observations with respect to the minutes. And the Lord Justice Popplewell indicated that there is a distinction between simply saying we've got minutes from 2002 and saying on the basis of these minutes we believe that the value of the property is £65 million. And the report obviously doesn't say anything about that, about the report being 3 years old. Now, Mr. Norbury introduces the notion that the judgment has found that there was an all valuation, contemporaneous all valuation by DTZ prior to the transfer. Now, obviously, the minutes don't mention that, which would be most peculiar if you had a ready means of producing and signing minutes honestly that recorded reliance on a contemporaneous valuation. You would have done so. More importantly, the judge never found that there was any oral valuation by DTZ, or that anyone had said that there was. The judge was clear in his findings. There had been no valuation from DTZ at the time of the board meeting. Now, paragraph 101 is inconsistent with Mr. Norbury's suggestion. Because having set out the items in paragraph 100, including paragraph 100.3 that my learned friend relies upon, at 101, the judge says, it is therefore necessary to consider, this is page 114, it is therefore necessary to consider whether, despite this, Mr. Brown believed the transfer price was the market value of New Court. Now, if the judge had been intending to say that Mr. Brown had been told that there'd been an all valuation by DTZ, the words despite this would not be there. The judge would be saying, on the basis of these facts, Mr. Brown would have believed the transfer price was the market value of New Court. Therefore, all that 100.3 is doing is Buckingham is recorded as chasing for confirmation before the minute could be signed off. Given the minute was signed off in the terms that it is obvious Buckingham then referred to the May 2000, we're referring to the May 2002 report, and not that all confirmation of the value of 65 million had already been obtained. We say, nor did the judge rely on this for his notion that an independent valuation was to be obtained subsequently, which, as we've seen, is inconsistent with the statement in the minute, in the accounts, that a valuation was not going to be obtained.
Have we got the email that's referred to in paragraph 100.3 anywhere in our rules?
No, I don't believe we have. Now, my final observation is with respect to my other friends' reliance on the judgment of paragraph 121. Remember the three types of valuation. We highlight the fact that the judge was simply referring to a passage in Mr. Brown's witness statement. And New Court was recorded, as the judge records at 110. You will recall that the New Court was in it at £70 million in the Iron Czar Trust schedule. Now, it's important to appreciate, as was recorded in the agreed narrative chronology, that these were in effect the trust accounts, which is rarely revealed to third parties. So this isn't a figure for the purposes of raising finance. So it doesn't really fit with just the fact that, oh, there was only those three types of valuation. And we say Mr. Brown clear in his evidence, he was particularly responsive to the judge, that the transaction in question required an independent valuation, as we say again. Sorry, I apologise to Lord Justice Popplewell. It's in our additional documents, tab 42. And the response is at 43.
So 41 and 42. Pages 171 and 172.
Sorry, yes, it's 41 and 42.
Sorry, 41, 42, apologies.
hive-up minute that's being referred to at 171 is the board minute of
18th of July.
Of 18th
Yes.
July.
Yes.
And somebody's written on page 172, complete board minute. Might suggest that it was following this exchange that minute was then
Yes.
finalised.
Yes.
So on the judge's findings, there was a board meeting on the 18th. There was at that stage the RTZ 2002 report. There wasn't a minute finalised at that stage. The minute we've got only came as a result of this exchange some 8 days later. Is that,
Yes.
is that sequence?
That's I think that's the way it was being approached. Chase for the valuation 26th of July, and then the minute prepared on the basis it was the 202 report, which the position of the respondents was, well, the minute was accurate, but
Well, the minute.
but the report that the minute's referring to was not the 2002 report. The judge found it was. So this minute is.
No, the judge found that when the meeting took place, the 2002 report was before the directors.
Yes. And that.
As to what the report was that was being referred to in the minute, once it was finalised 8 days later, I don't think the judge made any findings, did he?
I think he
But
did.
We can. He did.
I think he did. Well, I'm looking at paragraph 98 to see whether that's a sort of whether there can be any distinction on this. Because part of the reason why the judge reached the conclusion that he did is because of the correlation between the contents of the report as described in the minutes and the 2002 report. It talks about discussing tenancy rates or whatever. But there's a section, you may recall, page 52, that describes the report, and that's an accurate description of the 2002 report. And obviously wasn't in any way, didn't in any way correspond to the DTZ letter.
That might have been anticipated to be in the DTZ report, which was confirmatory of something which was understood to have been the basis on which the evaluation was given on the 18th of July by Popplewell.
The minutes are said to be accurate. The minutes are on the basis that there's a document that the board see at that meeting. There's no reference to any oral confirmation of anything of the sort. The contents that are as referred to in the minutes accord with the 2002 report. When end of July, they're chasing for the valuation, that would have been the time, had there been any contemporaneous valuation, the minutes to be produced referring to a contemporaneous valuation. Because there wasn't one, the only report was the 2002 one, and the respondents said, well, even though the minute was produced afterwards, referring to the 2002 report, those minutes were accurate. Therefore, on the 18th of July, they only had the 2002 report.
On the basis of the minutes, they say such advice was tabled, implying a physical document.
Yes, and that, as was accepted in cross-examination. Yeah. And then my final written observation is to point out Mr. Norbury didn't address the point that on his interpretation of the judgment, the judge simply ignores what was said, Mr. Brown said in cross-examination in response to questions I put to him about the various matters that we were relying upon for saying that he must have known that the transfers were going to be at an undervalue and or couldn't really accept the low figures that were in there as being genuinely the market value. Again, I do apologise if, of course, I've taken thought to be an inappropriate one. No, oh gosh, yes. On the experts, just very quickly then. The point being, the judge had a point about the uncertainties of Mr. Manley's appraising the development potential of the property in 2005. The point that wasn't put to him in cross-examination is just said to be another example of that. But the uncertainties identified were uncertainties that applied equally in 2005, and Mr. Manley's report points out that the contemporaneous valuations emphasised what an attractive property this was from a development potential point of view. Mr. Norbury is, as a practical and realistic matter, wrong to say all properties are capable of development. As I gave the court the citations for Mr. Manley's observations on two of the comparables, pointing out that they are properties that had recently been developed in 2001. So they weren't properties with development potential. Equally, you have properties subject to long leases. They have no development potential. The average that was being used as the starting point was of all properties, including, therefore, those with no development potential. So if you have a property which, as Mr. Norbury points out, has added value because it's a possibility of a profitable redevelopment, then that property is more valuable than the average. And the passages that he took you to from Mr. Whitfield's report indicate, and also on the previous page, he works on the assumption that the development won't add value. He says previous sentence, you may have a higher value, but he then works on the assumption that it doesn't add value. But it's not neutral because he then increases the yield by reference to two factors that disappear on a redevelopment: length of the term and age of the building. And that's why it's just illogical to accept what Mr. Whitfield said. Mr. Manley, he should have said, well, he should have said valuations are not a science. And Mr. Manley is a hugely experienced valuer. And there's no reason, therefore, to say, well, because he hasn't mathematically explained how he gets to his yield, that I reject the report. And in terms of my learned friend Mr. McCourt Fritz's submissions, I apologise for two things. We didn't seek to suggest that BXB had made any changes on the modern law. We just thought it would be helpful for the court to operate on the most recent authoritative statement of the relevant principles. And secondly, I apologise for the confusion caused by using the expression erred in law. I was always taught, perhaps incorrectly, that simply saying that the judge had an error of fact was insufficient for the very reasons my learned friends have emphasised. It has to be such an egregious error that it amounts to an error of law. Now that may be a misunderstanding of the position, but again, that's why my learned friend rightly says sometimes when we said erred in law, it is clear that we're taking issue with the factual findings, and we simply would say in the short time available, my learned friend's submissions with respect to shadow director simply don't take account of the paragraphs I highlighted from the judgment of 323, 301, 304, 309. And secondly, it isn't, the point about privilege, it clearly isn't open to equity trust during the course of the proceedings to insist that the privilege in legal advice is theirs, and then say that when the substantive issue as to which company was being, as to which entity was being advised, then say, well, it wasn't equity trust. And it isn't so much the question of whether or not the privilege could be maintained because of problems of confidentiality. It's the fact that the equity trusts are identifying themselves as the sole client of the advice that's being given. And then just finally on Miss Leonard's witness statement is at tab 72. And if you were to look at that, you would see that far from this being her statement that she took her duty seriously, being an additional factor, what you find is a bold assertion of that being the position. And then when she says how she discharged that role, we see her saying, I asked if the advice that had been taken was being followed, which brings me back to submissions I've already made. Thank you very much for being so attentive.
Anything else? No. In which case, let's just come back to Mr. Norbury. Mr. Norbury, I would guess, you can tell me if I'm wrong, that no particular concern would arise in relation to paragraphs 9 onwards, which follow the normal pattern of replies, submissions, and nothing particular seems to arise from them.
I think that must be right.
So when you rose earlier, it was in relation to the matters of common ground.
Yes, absolutely. Because I was getting lost by the density
Yes.
of the written submissions and unable to check the precise wording, and obviously very nervous about
Yes.
something being presented as a concession or an admission when it may or may not be. And I must admit, I thought this was an entire document at that point consisting of 10 pages of things that maybe I shouldn't have said or something. So
No. Have you had a chance to read through the section dealing with matters of common ground to see if there are any matters that you would wish to draw to our attention?
I think there will be one or two. I think on the whole, it is probably fair. There are one or two points that I would wish to just draw the court's attention to what was actually said. For instance, in the case of an unlawful dividend, any concession that might be interpreted from what I said is heavily qualified by the context in which it's said. So if I may have leave to sort of, I don't want to put in a further round of submissions, I'm not going to abuse the process, but to identify any factual points on that, although I must admit the court would realise that itself if checking the references. So I'm in your lordships and your ladyships' hands.
Mr. Norbury, what I think we'll do is say that you can have till 4 o'clock tomorrow to put in no more than a single sheet of paper relating only to that first section of the written document and also limited to pointing out to us any respects in which you say that the matters said to be common ground were not common ground, and referring us to relevant references to bear that out.
I'm very grateful.
Mr. Parker, there's no objection to that, I assume.
No, well, once again, I apologise. I see now, with the benefit of hindsight, that that's the document I should have endeavoured to get to Mr. Norbury sooner. Sorry.
Thank you.
We won't debate the rights and wrongs of that position.
May I make one point that is strictly a correction from my learned friend's reply submissions just now, and it relates to Hayes. Overnight, conscious of my Lord Justice Popplewell's experience of the case, I checked to see whether what my learned friend had said about the Gosh test is right. And it is and it isn't, because the underlying trials took place at different stages. And so although there is a direction to the jury that my learned friend relies on, that relates to one of the underlying criminal trials being pre-Ivy, there is also a direction where it is left to the jury post-Ivy, and just the reference is page 830 in the authorities bundle, paragraph 69 of the Court of Appeal's judgment, and the excerpt from the direction that was given to the jury there, post-Ivy, in which my Lord Justice Popplewell's question was put on the post-Genting, Ivy and Genting basis to the jury. So just as a
And on that, Mr. Parker must be entitled to the last word, should he wish to take it.
Well, it's not entirely clear as to whether or not that particular, it's about a deliberate disregard. It's not quite clear with us. I think that, I'll be
I'm
correct
afraid
if I'm
I
wrong.
can't remember whether Colombo is post Ivy and Genting, but we can easily identify whether it was.
I think it's the difference between the conspiracy and actually making the submission. If it's a conspiracy, then you have to require that you have to be asking that the person making the submission deliberately disregard their knowledge of what was required. Because obviously, if you don't know what the correct construction is of libel, then it doesn't get off the ground. But once the submitter knows what's required, that's the point of what they're doing would be dishonest. But if you're running a conspiracy where you're asking somebody to make a submission, you've got to ask them to deliberately disregard the requirements of libel. That's what I took from it. But you'll read it and no doubt decide what it actually said. Thank you.
Well, you won't be surprised to know that we're not going to give judgment here and now. In accordance with the normal practice, the draft will be supplied to you in due course for you to correct our typing in English, but not to re-argue the case. I'm sure you all have very well in mind the importance that is attached to compliance with the confidentiality obligation. The draft will be sent out to the addresses that you have supplied. If for any reason there's any question of wishing to disseminate it more widely, then plainly you have to come back and get permission for that. Also, in advance of the judgment being handed down, we'd be grateful if you would seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we would expect to settle the points in the order that we make. Thank those with speaking roles and those behind very much for very interesting and helpful argument.